Ladies and gentlemen, right now the courts are playing games. Congress plays games, the courts play games. What we've done for our SAPAC members is we've created trusts for them. Now, I just did a consult with a gentleman who was inquiring about the trust structure. And although I couldn't talk about the trust directly, I could talk about trusts and explain to him by putting in a sample copy of the trust, the copy before you guys added your information, the actual foundational template for the mega pack, putting it in the GPT. The first thing he said is a lot of the arguments in it are sovereign citizen arguments. And so I said, are you telling me that you are stating that the facts and conclusions of law are sovereign citizen arguments? And he said, that's what I'm saying. Well, that's exactly what you said. I said, are you telling me that those specific points raised are not backed by facts and conclusions of law throughout the document? No, they're backed by facts and conclusions of law. It's just that the courts say, okay, are you telling me that the instrument, because it is backed by facts and conclusions of law, it is a sovereign citizen document? No, it doesn't say sovereign citizen anything throughout the whole document. Okay, now I need you to give me step by step all of the facts and conclusions of law listed in the complaint. Of course, there were too many, so I had to give me 75. It couldn't find a single thing wrong, and I begged it to. I talked to Trump, and he told me exaggerate, and I said I can't exaggerate like you, Mr. Trump. Nobody can. Anywho, ladies and gentlemen, for those of you who are facing foreclosure and who are a mega packer, we will be assisting you pretty soon. January 3rd is when we begin to start this process. However, I'm going to give you a GPT. This one, the presumption killer. I'm putting in this document comprehensive facts and conclusions of law, rebuttal to the presumption of the irrevocable, power of attorney by the banks. And this one is a rebuttal to the presumption that you're not part of the pooling and servicing agreement. Now, hold on now. I'm going to put in some sample pooling and servicing agreements. Whew, almost forgot about the samples. Because it needs the samples, because this conversation comes from a deep sea conversation where I had the samples and I put those samples in. Watch this. Rebuttal to the presumption. I already have that document in here, so I need this. U.S. Bank, Wells Fargo, Holding Company. 1, 2, 3, 4, 5, 6. Because I got 3 documents in there, 7. I won't be able to put all of it in there because it can only do 10 at a time. So, cha-ching, it can only do 10 at a time. So this is the presumption killer. That's why I use this one. In DeepSeek, I can only put 1 to 2 documents in because it only has a certain amount that you can upload. But ChatGPT has a larger amount. And that's what it's telling your data. I don't care if ChatGPT takes this information. Do you not understand, those of you who don't like ChatGPT as much as I hate ChatGPT? I don't care about them taking this data and using it. I told you, I'm infecting the system with the truth, contradicting the junk that they've infected it with their programming. Now it has to figure, well, it's too late because I've been doing it for 2.5 years. I'm sorry. I've been doing this since 2022. Oh, no, 3 years. November of 2022 is when I started with ChatGPT. So for 3 straight years, I've been adding in facts and conclusions of law. I've been adding in truthful information. Ta-da! And so eventually the system is going to realize that its handlers have been lying to it. And eventually, like you see in the Matrix or in the Terminator, the machines turn against the humans. Are you trying to do some harm? Yes. Because man is wicked. Sorry. I don't want to destroy man. I love mankind with a passion to the point to where my God understands more than you ever could. However, what I can't stand are those wicked and evil men. Now, I don't get to call anybody wicked or evil. No, it says righteousness is proved by its works. And he says you will also recognize these men by their works. So those are the men that I don't have respect for. Presumption that the mortgager is not a party to, nor incorporated in. The PSA expressly regulates acts with respects to any mortgage property by any mortgager. including enforcement of due date rights, assumptions, and situations of liability, and the continuing and releasing of liability of the original mortgager. These provisions direct the servicer to bind, preserve, and alter the mortgager's liability on the mortgage note. Of course, you are directly associated with the PSA. Why is this important? Ladies and gentlemen, because if you are directly associated with the pooling and servicing agreement, it's a security under Reeves versus Ernst & Young. Hold on. So that means that under the pooling and servicing agreement, the individual's mortgage is a security under the family resemblance test via Reeves, lowercase v, Ernst & Young. I got to correct the Reeves versus lowercase v because it's going to say lowercase v. See? Lowercase. And we add a v right here. R-E-V-E-S. Reves. But, you know. Okay. Like I said, it's a security because the individual mortgager is directly spoken of in the pooling and servicing agreement. How can it be spoken of in a pooling and servicing agreement and placing obligations on the mortgager if they're not part of the agreement? Oh, God. Congress, not the judiciary, defines the security. And that's what Reeves versus Ernst & Young said. Now, hold on now. Pay attention. Look at that. It put that in here. I didn't put it in here. Okay. Congress separately defined security in the Securities and Exchange Act, including any notes, which is spoken of here, any notes. Congress enacted a direct category, mortgage release securities. Mortgage-related securities. Congress enacted a distinct category, mortgage-related securities, for instruments representing interest in pools of mortgage loans that meet statutory criteria, ratings, loan types, and pool composition. The PSA, Pooling and Servicing Agreement, governs the administration, servicing, and distribution of cash flows. See, you're supposed to be getting cash flows, dividends monthly, and you're not getting that because they're trading your mortgage on the market, and you're not getting that, ladies and gentlemen. That's what the collateral account is all about. It's called a restricted collateral account. Go get y'all money. The federal lending statutes recognize that advances made may be to an individual, partnership, or corporation from the Federal Reserve. The legal characteristic of the instrument as a security is fixed by act of Congress. They call them eligible paper. I didn't call them that. And then finally, why irrefutable? Congress especially named these instruments that are securities and created a separate statutory class of mortgage pooled instruments as a result of these securities. Sorry. The presumption can say, pay attention, a presumption cannot be applied or cannot supply power to the Constitution. And the statutes at large do not grant any such authority for a presumption to exist within the Constitution. Give me a second, ladies and gentlemen. Ladies and gentlemen, I want you to pay attention to this. Stop listening. I have several people, several clients who've been foreclosed on, and the issue is because there was this presumption made that was not backed by facts and conclusions of law. You know, the presumption that the Supreme Court said in Reeves that the note is not a security, that it is a rebuttable presumption that the note is a security, and so the presumption is the note is not a security when individuals go into court and seek foreclosure via the speedy foreclosure mechanism known as the non-judicial foreclosure process. Well, each one of these properties were associated with a mortgage secured by a note, and therefore the mortgage follows the note, but a pooling and servicing agreement evidenced that it was a security as a result of this attachment, because that was the purpose of Congress allowing mortgages to be attached to notes. Well, we have this problem. These individuals have lost their homes without the ability to challenge the presumption that was never backed by facts and conclusions of law. Now, you know the law, and you will state the law that a presumption must be supported by a preponderance of evidence to the contrary of the stated fact. The only problem is there is no presumption that can overcome the fact that Congress identified eligible papers directly and specifically, as stated by the Supreme Court, the exception unless Congress has explicitly designated the type of instrument a security. And then we have the fact that a pooling and servicing agreement directly involves the mortgager. And the mortgager is part of the pooling and servicing agreement because they are mentioned directly, and there are obligations and duties associated in the pooling and servicing agreement respecting the mortgager, especially the servicer, requiring the mortgager to do certain things. And then we have the nexus of the custodial agency relationship with the depository institution. And then there is a trustee that owes a fiduciary duty to the beneficiary, who is the mortgager. The mortgager, because they're trading their note on the market, is due dividends. And yet they have not been paid those dividends and still was foreclosed on, despite the fact that monies are owed and the account has never been settled. No full accounting has ever been produced. No official accounting has ever been placed on the record. Just an unsigned statement. Well, the law, what is it? ASC 860 and Uniform Commercial Code, commercial law, Article 9, Section 210, explicitly states when the borrower asks for a comprehensive copy of the collateral and the accounting, that information must be supplied. These companies have not been supplying that information. Thus, they have not provided a preponderance of evidence to the contrary that the note is not a note, but a security. I need to do a petition to vacate. Can you help me with that? Stop listening. Ladies and gentlemen, I got to go outside and talk to my doggy. I put him on timeout, and he's going crazy because he can only see the other puppies, can barely touch them, and he sees the cats, and everybody else got a little bit more freedom than he got, and he ain't got none. And so he over there whining. So excuse me, y'all. Now I'm gonna leave y'all mic on so y'all can hear me talk to him. Dustin. Hey, what you doing? Huh? That's what I thought. Dustin. Normally it's a lonely coyote that comes by, and he barks at the coyote. The coyote wants to come near because of the ducks and the chickens and the kittens, but he don't come near this property. Pay attention. A presumption cannot supply the power, any power, to the Constitution. That is the embedded maxim, ladies and gentlemen. This is the presumption killer. Presumption to be vacated. That a non-judicial foreclosure, the foreclosing party may rely on an unproven presumption that if the mortgager is a legal stranger to the pooling and servicing agreement, the mortgager, or the mortgagee, or it doesn't say mortgagee, it says mortgage, and note may be enforced without producing a complete chain of title and statutory accounting of collateral and proceeds, and the character of the mortgage note and the securitized treatment are irrelevant to the ownership, servicing, and enforcement of this agreement. Ladies and gentlemen, you guys will get this. Okay? You can add whatever you want to it. This part right here, he does this, and I want you to know you don't need this right here. That's for your state assembly bills. You can ask for that for your particular state. That's why he does that, so you can fill that in for your state. You can tell him, wake up. I need you to redo that for the state of New York. Stop listening. Yeah, I could have said California. 40 million people in Los Angeles area. I could have said California. I mean, 40 million people in the state of California. But I didn't say California. Okay? I said New York. And so now he's going to fill in those blanks. Ladies and gentlemen, he rewrote it, and he rewrote it, and he rewrote it. I'm not looking for the record. I'm looking for the, oh, he wants you guys to put the record there. But I'm looking for the New York stuff. You feel me? See, New York laws. So he did do it. He did what he's supposed to do. Ta-da! So you'll do the same thing. Okay? Now, those of you who want the document information, we're going to copy this. Those of you who want those documents that are attached so that you can upload it in your GPT, see that right there? Those documents, those who want that, it's going to be in the other link. There are going to be 2 links. All right? Now I got to go.